Right now, as you watch this, there is a house sitting empty in Sacramento, California. The woman who lived there, a 61-year-old retired schoolteacher, died 9 months ago. She had 2 adult children. She had a paid-off home worth $410,000. She had a retirement account. She had everything in order, except one thing. She had no will, no trust, no estate plan. 9 months later, her children still cannot sell the house. They cannot access her bank accounts. They cannot touch her retirement savings. They are paying the mortgage insurance, the property taxes, and the utility bills on a home they cannot legally control, while a probate court in Sacramento slowly, methodically decides what happens next. By the time that court is finished, an estimated $25,000 to $35,000 of their mother's estate will have been consumed by legal fees, court costs, and administrative expenses. That house she spent 30 years paying off? Her children may have to sell it just to cover the cost of the legal process that was supposed to give it to them. And this family is not unusual. They are the norm. Nothing in this video is legal advice. Every situation is different, and if you need guidance for your specific circumstances, consult a qualified estate planning attorney in your state. According to the most recent data, 76% of Americans will die exactly the way that woman did, with no will, no trust, and no plan for what happens to the people and property they leave behind. 3 out of 4. If you're in a room with 3 other people right now, statistically, 3 of you have no legal document telling anyone what to do with your money, your home, or your children after you're gone. This is the most expensive mistake in America that almost nobody talks about. And today, we're going to talk about it. Welcome to The Day After You Die, where we uncover the truth about what happens to everything you've built. If you want to protect your family from the traps that destroy estates every single day, subscribe right now and turn on notifications. This is the most important financial education you'll never get in school. Let's start with what most people think happens when they die. Most people assume that when they pass away, their spouse gets everything, or their children, or whoever they've told, verbally, over dinner, casually, that they want to have their stuff. Most people assume that because they told their daughter she'd get the house, or because they told their son he'd get the savings account, that's what will happen. It won't. Unless your wishes are written down in a legally valid document, a will or a trust, your words mean nothing after you die. It doesn't matter what you said at Thanksgiving dinner. It doesn't matter what you wrote in a text message. It doesn't matter what your spouse just knows you wanted. The moment your heart stops beating, the law takes over, and the law doesn't know you. The law doesn't care about your relationships, your promises, or your intentions. The law follows a formula. That formula is called intestate succession. Intestate simply means dying without a will, and every state in America has its own version of this formula, a rigid, mechanical set of rules that dictates who gets what, in what order, based solely on legal relationships. Not emotional relationships, not the people who actually cared for you. Legal relationships. Here's how it typically works. If you die without a will and you're married with children, in most states your spouse does not automatically get everything. In many states your spouse gets a portion, sometimes half, sometimes a third, and the rest goes to your children. Now, if your children are adults, that might sound fine. But if your children are minors, a court will appoint a guardian to manage their share of the inheritance. And that guardian might not be the person you would have chosen. If you're not married, the formula usually sends everything to your children. If you have no children, it goes to your parents. If your parents are gone, it goes to your siblings. If you have no siblings, it goes to your nieces and nephews. And if the state can't find anyone in the formula who qualifies, your estate goes to the state itself. At no point in this process does anyone ask what you actually wanted. At no point does a judge say, well, this person's best friend was really like a sister to them, so let's give her the house. That doesn't happen. The formula runs. The formula decides. The formula doesn't care. And the formula creates nightmares that real families live through every single day. Consider what happens to your house. For most Americans, their home is their single largest asset. It's the thing they worked hardest to pay off. It's the thing they most want their children to have. But if that house is titled only in your name and you die without a trust, that house must go through probate before anyone can legally do anything with it. Probate is the court-supervised process of settling a dead person's estate. On paper, it sounds orderly. In reality, it is slow, expensive, public, and often devastating for the families caught inside it. The average probate process in America takes 16 months. In some states, it can stretch to 2 or 3 years. During that entire time, the house sits in legal limbo. Your family cannot sell it. They cannot refinance it. In many cases, they can barely maintain it. But they're still responsible for paying the taxes, the insurance, and the upkeep on a property the court won't let them touch. And probate is not free. The total cost of probate typically runs between 3 and 8% of the estate's total value. On a $500,000 estate, which is what a modest home and a retirement account might total in much of the country, that's $15,000 to $40,000 in fees. Court filing costs, attorney fees, executor compensation, appraisals, publication requirements, accounting fees. It stacks. And every dollar of those fees comes out of the estate, which means every dollar is money that was supposed to go to your family. In California, the numbers are even worse. The state uses a statutory fee schedule based on the gross value of the estate, not the net value after debts. That means if you have a house worth $600,000 with a $400,000 mortgage on it, California calculates probate fees on the full $600,000, even though your equity is only $200,000. The legal fees alone on that estate could exceed $30,000, more than the equity in the house itself. And here's what no one tells you about probate. It's public. Every filing, every asset, every debt, every beneficiary dispute is part of the public court record. Anyone can look it up. Anyone can see what you owned, what you owed, and who's fighting over it. The privacy you maintained your entire life disappears the moment you enter probate court. Now let's talk about something even more frightening: your children. If you have minor children and you die without a will, you have left the most important decision of their lives, who will raise them, entirely to a judge who has never met your family. Without a will naming a guardian, the court decides, and the court's decision is based on legal criteria, not your preferences. The judge will consider factors like the closest biological relative, financial stability, and proximity. But the judge does not know that your sister has a drinking problem. The judge does not know that your brother-in-law is controlling. The judge does not know that the person you actually trusted to raise your children is your best friend from college who isn't related to you by blood. Without a document naming that person, they have no legal standing. Your children go where the court sends them. And if family members disagree about who should get custody, the result is a guardianship fight, in open court, in the middle of your children's grief, that can take months and cost tens of thousands of dollars. All of it paid from the estate. All of it money that should have gone to raising your kids. This doesn't happen to other people. This happens to families just like yours, in every state, every single week. So let's talk about what actually protects your family. The tools exist. They're not complicated. They're not expensive, and they work. The first tool is a will. A will is a legal document that tells the court 3 things: who gets your property, who you want to manage the process of distributing it, and if you have minor children, who you want to raise them. A basic will costs between $200 and $1,000 to create with an attorney, depending on where you live and the complexity of your situation. Online platforms offer simple wills for even less. There is no legitimate reason for any adult with children, property, or savings to not have a will. But here's what most people don't realize. A will does not avoid probate. Your family still has to take that will to court. The court still has to validate it, appoint the executor, supervise the distribution, and sign off on the final settlement. A will makes probate faster and cheaper, but it doesn't eliminate it. The tool that eliminates probate is a living trust. A revocable living trust is a legal entity that holds your assets during your lifetime and transfers them to your beneficiaries after your death, without ever going through a courtroom. You create the trust. You fund it by retitling your assets, your house, your bank accounts, your investments, into the name of the trust. You remain in complete control during your lifetime. You can change it, revoke it, add to it, or dissolve it at any time. But the moment you die, the trust activates. Your successor trustee, the person you chose, follows your written instructions and distributes your assets to your beneficiaries. No court, no judge, no public record, no 16-month waiting period, no 3 to 8% fee. In most cases, the process takes weeks, not years. A comprehensive estate plan, including a living trust, a pour-over will, a financial power of attorney, a healthcare directive, and a living will, typically costs between $1,500 and $5,000 with an attorney. For the price of a vacation, you can ensure that your family never has to set foot inside a probate court. Now compare that cost to what happens without it. Probate fees on a $500,000 estate, $15,000 to $40,000. Legal costs if family members dispute the distribution, another $10,000 to $50,000. Months or years of frozen assets. A home your children can't sell. Retirement accounts your spouse can't access. And guardianship decisions made by a stranger in a black robe. The math is not close. Here's the reality that this entire video comes down to. The day after you die, one of two things will happen. Either a person you chose will open a document you wrote and calmly follow the instructions you left to take care of the people you love. Or a court will open your file, assign a case number, and begin a legal process that could drain your estate, divide your family, and last longer than your children's grief. You get to decide which one, but only while you're alive. 76% of Americans will not make this decision in time. They will leave it to the state. They will leave it to the courts. They will leave their family holding the bill. Don't be one of them. Thank you for watching. If this video changed how you think about protecting your family, do me a favor, share it with one person you love, just one. Because the conversation this video starts could save them thousands of dollars and years of heartache. And if you want to go deeper, the next video on your screen is one you won't want to miss. I'll see you there.